This morning on the Ag Issues program, a pleasure to bring, as always, onto the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Happy Memorial Day.
And the same to you as well. Today, we're going to get a couple of articles that you recently wrote on your blog, and first off, I want to ask, and they can pick these up right now on your blog?
That's correct, yes.
Okay. So the first thing we want to talk about, in one that you just recently wrote, I believe you posted it on Friday, and it's about farmland title fraud, and it's starting to become a growing problem in rural America. So probably the first thing I want to ask, what exactly is farmland title fraud?
Well, Greg, and that's a good question. And I had heard kind of second and third hand of something going on in Kansas and across the country. I think it was back in February, and I made some notes. I thought, well, I'll eventually do an article on this, but I kind of set that aside. I had a bare-bone outline started of what I was hearing and what I was thinking might be some issues that would come up. And then it was a week ago today, I get a call from an individual that owns ranch land out in western Kansas who doesn't live in Kansas. In fact, flies for a major airline internationally. Lives in Texas, but had come up to his Kansas place and was driving out to his ranch and his first track. He has tracks in different counties, and noticed that there was a sign on it, a for sale sign. And so he called the realtor, the real estate agent that had it listed, and that's when he first realized that there was a problem here. So what it is basically is scammers impersonating landowners and trying to sell farm and ranch land that they don't own. And in many cases, they're getting dangerously close to succeeding, and probably would have succeeded in this instance had, just not by happenstance, he driven out to his ranch.
So let me ask then, in this case of farmland owners, why are they especially vulnerable to these scams?
Well, it goes to the facts of this fellow. You've got vacant land. Nobody lives there. There's no structures on it, although he has an oil well on the second tract out there. But it's a real unique opportunity for criminals. There's no occupied structure. There's no daily activity. There's cattle on it, but there's no people around. So there's no one around to notice unusual activity. And many owners like this fellow live out of state, and they visit only periodically. They conduct business remotely. And so vacant farmland, hunting property, recreational tracts, pasture ground, out in western Kansas, it'd also be mineral producing property. They're particularly attractive targets because they have substantial value but remain largely unattended. And so you've got these scammers that are looking at public records for absentee landowners, and then they build fake identities around publicly available information, such as legal descriptions and tax mailing addresses and ownership history, and even they look up family details. The fraudster knew who he worked for. They knew he lived in Texas, and they had all types of information concerning him, and they completely spoofed his identity and fooled the real estate agent. It's a big issue, and so they get armed with all that data. They contact a real estate agent pretending to be the owner and try to push the transaction through rapidly. And even the agent, in this instance, when he said who he was, the agent said, "Oh, hi, how are you?" And he said, "I don't think I've ever had a conversation with you." And long story short, she had an offer on one of his tracts, and of course he didn't want to sell it. So they don't just try to sell it. There's also a parallel lucrative scam that involves fake deeds or forged lease agreements to enroll land in USDA farm programs. So I'm finding that it's a big issue. In fact, Greg, I talked to the real estate agent that sold us our place here in Kansas, and she said, "Oh, Roger, I get one or two of these every single week." It's that big of a problem.
And everything that you just described, it sounds like some of the classic, I guess you would call it the factual scam signs, or at least warning signs that are out there as well, that are fraudulent sales taking place.
Yeah, you got the seller that's insisting on communicating exclusively by text or email, which is what happened in this situation. And that supposed owner claims to be overseas or traveling, or they're in the hospital, but they're not available for a phone call or a meeting. And that another telltale sign is they try to push the transaction through very, very quickly on a rush basis. And then the asking price is set slightly under market value to attract immediate buyers. And you've got electronic signatures that are heavily relied on, and the property owner, of course, as I said, is an out-of-state resident. Those are kind of the telltale signs, the red flags that you want to look for in these situations.
So seeing that as well, and if a fraudulent deed or sale actually occurs, I'm curious, how serious can the legal and financial fallout become?
It can be severe. I mean, you could end up with a cloud on your real estate title. Now, of course, had this sale gone through on the example I gave you that I was told about, the buyer's going to get a void title. And what's going to have to happen there is now you got to, as the true owner, you got a cloud on the title. Of course, the fraudsters got their money, and now the buyer's got a bad title, and they don't have anything. So that title issue's got to be cleared up. That cloud has to be removed. You're going to have extensive litigation expenses, delayed financing on other projects, probably fraudulent liens or recorded instruments. You're going to have insurance complications. And then if it's on ground that's leased for mineral rights, you're going to have disputed mineral leases and royalty payments. And then, of course, the emotional stress and uncertainty. It's just an absolute mess.
So hearing this, if you're a landowner like that, what are some of the practical steps that landowners could take right now to protect themselves?
Well, one, you have to monitor county records. Some counties now offer free property fraud alert systems that will notify owners if documents are recorded against their names or parcels. So contact the local register of deeds or recorder's office in the county to enroll in that if it's available. And then make sure county tax offices and deed records contain updated mailing addresses and phone numbers and email addresses. If your information is outdated, that's going to delay the discovery of any fraud activity on that property. And then, of course, maintain good relationships with people in the area, neighbors, tenants, farm managers, veterinarians. Actually, the tip in this case I was telling you about that I got the call on last Monday, this individual happened to go to town and ran into the veterinarian, and the veterinarian tipped him off that there was a for sale sign on one of his properties, and that's when he drove out and saw the sign. So maintain those good relationships and talk to people. Even I would throw in agronomists and other farmers in the area, because they typically see the property. So make sure your trusted local contacts have your direct contact information. And then I'd say periodically search online real estate platforms for unauthorized listings that might involve your property. You might just be able to check it that way. And then on the other side, real estate professionals should bypass standard video conferencing links that are provided by unknown clients. The thing with AI technology here, Greg, they can spoof a video call or even a Zoom call. So these meetings with these clients need to be in person. This is one of the dangers of AI that can be used by the fraudsters in this instance. So I'd say all of those are kind of precautions and practical steps, common sense steps that people should take just to kind of stay on top of this.
Well, and talking about all that, it should scare, in some aspects, the landowner, the family, or whatever the case is. So bottom line, what's the one thing that you think farm families need to understand about this issue?
Just be aware. Be aware of things, critical awareness, technological caution. Be aware of what's going on technologically, and then local vigilance. Again, as I come back to what I mentioned just a moment ago, stay in contact with the local people in that area. If you're an absentee owner, and there are a lot of those in Kansas. If you want to think about this, break it down just to Kansas in the rural areas, there's a lot of land that's owned by, for example, a surviving spouse that no longer lives out there. But try and stay in contact with the people in the area. I think this local vigilance, along with keeping an eye on technology, contacting county officials, making sure your documents are updated, those are the only ways to safeguard your legacy in this instance. So a lot of common sense things, but you got to be aware of them. I imagine many people listening had not even thought of this. I hadn't really thought of it until I was starting to hear some things earlier this year. And again, as I said, I kind of set it aside until last Monday when I got the direct call.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest on the program, talking about a couple of recent blog articles that he posted that are of discussion today. And Roger, you recently posted a contracts article, and the recent article you posted focuses on the phrase, time is of the essence, quote unquote. So what does that phrase actually mean when you're talking about specifically with a farm contract?
Well, Greg, under traditional contract law, courts will often assume that exact timing is not automatically a material part of the agreement unless the contract explicitly says so, or the circumstances would demonstrate that timing is critical, or you've got one party that later gives notice that makes strict compliance necessary. So if you don't have that clause in the contract, a court might permit a reasonable delay or substantial compliance if the delay doesn't materially harm the other party. So if you add that clause in, that's going to change the analysis dramatically if there's some type of dispute that arises. So when you've got a contract that says time is of the essence, deadlines then become a material contractual obligation. And if the one party fails to perform on time, then that may constitute a material breach of the contract that allows the other party to either terminate it or refuse performance in return, or retain any earnest money, or accelerate obligations, or seek damages, or pursue any other remedies that might be available under the contract.
So why, in this case, timing, what becomes especially important in this case in agricultural transactions? Say, let's compare that to ordinary business deals.
Well, and this is something I think a lot of farmers and ranchers overlook. Ag transactions are uniquely sensitive to timing problems because farming operates within biological and seasonal and market-driven constraints. So if you've got a delay, that might be insignificant in another business context, but that can create substantial economic consequences in agriculture. And that's really, really important. The timing issues come up so frequently in agriculture, and we don't want to miss those deadlines. So I think this clause language is very important, perhaps more important in the ag industry than it is in many other industries.
So let's say, what are some examples, where missing a deadline by even a short amount of time can often create, let's say, major legal or financial consequences for farmers or ranchers?
Well, okay, let's say that I want to buy some farmland, and I've got the expectation of taking possession before spring planting. Well, if the closing is delayed by several weeks, then I might miss my planting windows. I might lose rental opportunities. It might disrupt my financing arrangements. It might jeopardize government farm program participation because there are deadlines that are associated with that. And then there are, of course, weather opportunities and windows that are associated with the other ones. And then I don't want my closing to be delayed by lender underwriting issues or probate complications if I'm buying out of an estate. Could end up with title defects and IRS lien releases or survey disputes. Those are all tied into the timing issue. So if I don't have a strict timing provision in my contract, courts are often reluctant to impose, say, a harsh forfeiture remedy when the delay causes little actual harm that the court can see. But it can be material harm because of all these unique aspects that are tied to agriculture. And the same thing can come up with respect to farming leases, very time sensitive with respect to rent payments and possession dates, irrigation obligations, or if we're running cattle, livestock removal, and even notice of termination, that can come up. And so this issue comes up in many, many instances.
Well, and you talked about some of those situations. It sounds like that are just some of the examples of, say, missing a deadline by even a short amount of time, where it can start to create, I would assume, major legal and financial consequences for farmers and ranchers.
Yeah, it can all across the board. I mentioned farm leases, but in purchases of farmland, you could throw in installment contracts on that too, but also your crop input and marketing contracts. Timing also matters there with respect to my seed and fertilizer delivery, grain marketing agreements, livestock production contracts, custom farming arrangements. Because if I get a delay in seed delivery during planting season, that might prevent timely planting altogether, or delayed fertilizer application. It might end up in reduction of yields for me. Delayed delivery of feeder cattle. You just think you could kind of just go down the list in your mind. Many farmers and ranchers listening could say, yeah, here's another issue. If I'm late on that, I'm dependent upon that hitting a certain time window, because then I can run into weather losses and quality discounts, or lodging damage, or lost marketing opportunities. So the list goes on and on. I can't overemphasize how important a time is of the essence clause is in a written contract. And that's a whole other issue right there. We need to get these contracts in writing and then have the clause in it to really get the best protection that we can possibly have.
I assume that there are some people that assume that a missed deadline can comply, that be worked out informally, even though that legally may or may not be the case.
Yeah, we don't want to assume things because a time of the essence clause can significantly strengthen the seller's ability to declare default payments if they're late, even by a short period. But and this can be risky for younger operators. We just don't want to assume that things are going to be worked out. That may not be true, and the other party may not be bound by statements or conduct. There may not be enough there for a court to determine that the other party should be bound. So we really need to have this clause in writing.
Well, besides that, what other practical advice would you have for producers and landowners when they sign contracts containing time is of the essence language?
Take the time to have the contract professionally drafted and have the clause included. Make sure that it's clear. Specify your exact dates and for performance and performance obligations and the remedies for noncompliance, and require written modifications, and avoid conduct that's inconsistent with strict enforcement of that language. And if you're desiring flexibility, there can be cure periods that can be put in for delayed performance, and clarify whether substantial performance is acceptable. But my whole point on this is we're better served if we take the time and spend a little bit of money to get this language drafted into a well-written contract than trying to battle this out in court later and deal with the headaches that have been caused by a delay in performance.
All of this said, bottom line, what's the biggest takeaway for farm families and ag businesses of the topic we just discussed?
Get it in writing. Get it right. I can't overemphasize that. I can't tell you how many times I get contacted with a contract issue that has come up because it was just based on he said, she said, there was a promise that was made. I changed my conduct in reliance on that. Now I've missed, for example, say a planting opportunity. And it just was all done on an oral basis. And I know that's very common in agriculture, but my message is, try to take the time to get these things in writing. That's really going to help you in the long run.
And again, Roger, of the topics we just discussed, they can find those on your blog?
They can, and they are also over on Ag Manager, although the real estate one I put up on Friday, and that won't come up on their site until tomorrow. But they're available through my website. You can find my blog there. So washburnlaw.edu/WALTR, and then you can search for my blog, and it will take you there.
All right, sounds good. Roger, as always, appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.